I'm Kirk Langefeld, one of the attorneys here at Hawbecker and Garver. Today I'm going to talk to you about the Multiboard 8.0 contract, paragraph 30 of confirmation of dual agency, and paragraph 31, sale of buyer's real estate. So here is where we get into these sections that are only applicable if initialed. So the first paragraph, paragraph 30, is confirmation of dual agency. So when there is only one agent, it must be confirmed that both parties agree that they are both using the same agent. Now, there are instances where one agent represents only one party and not both, but in the instance where an agent is representing both parties, this section must be completed and initialed. Now, another important provision that is used in the contract is the sale of buyer's real estate. And this is used when a buyer cannot purchase the property without selling their current property. It's called the home sale, home close contingency typically. So when you're going to use this paragraph is when the buyer says, well, I must sell my current house before I buy this house. So you're going to fill in the address of the current real estate. And then depending on when you're submitting this offer, there could be many different scenarios of where your client or your buyer is at with selling their property. If the buyer hasn't entered into a contract yet, you're going to say has not. And if they have, you're going to say yes, they have. And it may be also subject to a financing contingency, and real estate sale contingency, or real estate closing contingency. It is important to put this information into the contract so the seller is aware of what the situation is. If the buyer has not entered into a contract already, you are going to know whether it has or have not been listed yet. If they have entered a contract and they have been listed, you're going to put that as well. If you haven't, in paragraph 4, they're going to put the information for when it's going to be listed, where it's going to be listed, or if it doesn't intend to be listed. So that is all the information about the contract that your buyer will be entering into in order to purchase this next property. So now let's get into the logistics of how this works. There are two components. One is the home sale, which a home sale is upon entering into a contract for the sale. That is not the closing. That is the contract just for entering into a contract. And the date will be used there. And sometimes it's a week later, sometimes it's a couple weeks later. Or if it's already been completed, you can put in the date that your buyer has already entered into the contract. You put the date there to show that you've already entered into that contract. Now, under paragraph 2 is the home closing contingency. So what that means is that the property has closed, what date the property has closed. And often, if you're needing to sell and purchase, those can fall on the same date. Sometimes with post-close possession or an instance like that, or other situations that are worked out, you're going to put in a date earlier, whatever date that you have agreed to close on the buyer's sale. So that is important. So now that you've filled in all of that information, it is important to know that if that contract you've entered into is terminated for any reason, the buyer must provide notice to the seller. Provide notice, and on providing that notice to the seller, the buyer has two options. One, they can cancel, or 2, they can waive that contingency. Now, in many instances, you're going to use that opportunity to cancel to hopefully keep the seller in the contract with you to say, yes, this one canceled, we're taking the next one right away, keep things together. But that cancellation right is what allows you to potentially get another contract as well without waiving that contingency. If the seller doesn't agree, the contract's going to be terminated, and the buyer will get their earnest money back. Now, this is not just a right for the buyer. This also includes rights for the seller, and the seller does have the right to continue offer the real estate for the sale, real estate for sale. So they could potentially find a buyer that is not contingent on the sale. And when that does happen, they take an offer, a backup offer there they want to take instead of this offer. This section goes into effect, and there are notices. the seller provides notice to the buyer, which is essentially a kick-out notice. Hey, we are kicking you out of this contract to go take on another contract. And that notice must be in writing and provided to the buyer. In this set line 472, there's going to be a number of hours included there, 48, 72, 24. It's very key that as a seller, you want to have a very short window so you can accept your next offer if this buyer isn't going to proceed. So whatever amount of time is used there, that is when the ticking clock starts. So onto the logistics of the notice. So the notice must be provided only subject to the to this subparagraph, not in the rest of the contract, which provides that notice to an attorney is acceptable. In this case, unless modified in attorney review, notice must be provided by personal delivery, by mailing to the address, or by commercial overnight delivery, FedEx. So it can't just be a text message. It can't just be an email. It does need to be provided directly to the buyer unless, again, it's modified in attorney review. And once received, that starts that ticking clock. So let's assume that notice has been effective. The ticking clock has started. What does the buyer do? Well, the buyer can choose to say, we are waiving our contingency and proceeding with the contract without the contingency. If that's the case, then the kickout clause is not effective and the seller must continue with the original buyer for the sale of the property. Now it'll be without that contingency. Now, part of that waiver is addressed in paragraph D here, where it'll say additional earnest money might be deposited. Now, that is additional earnest money must be deposited at the same time or within that time period for the kickout clause. So it's very important that buyers know what they're doing and that if they do intend to waive that contingency, how they will proceed and move forward to keep the seller in the contract so they don't get kicked out by that notice. It's a tricky time for any buyer with these contingencies, and anytime they can do anything better, that is always good to make sure that they can get to the purchase of the property. I hope that's been a helpful primer to dual agency in the home sale, home close contingency section of the 8.0 contract. Feel free to reach out to me with any questions. Thank you for watching.